Welcome to Notable Approvals. I am attorney Amanda Shaffer, and welcome again to our viewers on Instagram. Before I get to our case today, just a reminder to like us and follow us on Facebook and Twitter and Instagram and LinkedIn, and follow us on YouTube so you don't miss any more of our lives. Today we have a pretty quick notable approval, but a very interesting issue and a very important lesson that you can learn from this case. This case is about a client who is a native and citizen of Mali. He came to us after, so before I get to that, he initially entered the US with a B2 visitor visa. Subsequently, he married a US citizen and she filed an I-130 petition for him. And he concurrently filed an I-45 adjustment of status application to get his green card. So he then came to us after his I-45 application was denied. And the reason it was denied is because they had sent him an RFE that said to provide proof of his Cuban citizenship. I just said that he was a native and citizen of Mali. And on all of his applications, and he wrote he's from Mali, he was born in Mali, he gave his Malian passport, the visa was issued in Bamako. There was nowhere, anywhere that he said he was Cuban. So the client didn't respond to the RFE because clearly it was a mistake. He's not claiming to be a Cuban citizen. And there is a certain type of adjustment of status that is specifically for Cuban citizens, but that's not what he was applying for. So he came to us and we saw this, and they denied it because he didn't respond. But the fact of the matter was they shouldn't have issued the request for evidence in the first place, since he's not a Cuban citizen. So as I've mentioned in other lives as well, that whenever there's a denial, we always look at it and say, is it better to refile, or is it better to appeal or do a motion to reopen or reconsider? In this case, motion to reconsider was the best option because the USCIS was just wrong. They were wrong on what the facts were in the case, and they applied a law to facts that didn't exist. So we filed the motion to reconsider. We put in copies of the application again, the passport, the visa. We explained that, here's the RFE. The reason he didn't respond is because it wasn't relevant. You can't deny it for not responding to something that's not relevant, because they're essentially, the denial said you didn't prove your Cuban citizenship. So that's wrong. That was quickly granted within a couple of months. And then he was able to finish up the green card process, and that was approved relatively easy after that, after it was the case was reopened or reconsidered. So this case is an interesting one because this is not the first time that we have gotten a request from evidence for USCIS asking for something that was not relevant to the case, or asking for something we already submitted, and we always respond. Even when it's not relevant. If it's not relevant, we would have written back, this is not, he is from Mali, not from Cuba. There's nothing that says he's from Cuba, because if he would have checked the wrong box on the form, that could have set it off, but that wasn't the case. And we've definitely had many times them tell us we didn't send in evidence that we sent in. So the lesson to learn is, if you get a request for evidence, even if you're like, I gave it to them already, this doesn't apply to me, I don't know why they're asking it, whatever the reason, whatever the request asked for, you have to put in a response. There is a small chance it can get approved if you ignore it when it's not relevant to you, but greater chances are they're just going to deny it. And it worked out for him, obviously, because we handled it. We did the motion to reconsider, and that wasn't a problem, but it still cost him more money. It cost him more time. It cost him more stress and anxiety. And it's, in my opinion, not worth it. But the fact of the matter is, USCIS wants a response. That's just by the book. It says in that letter, in the request for evidence letter, if you do not respond within 87 days, we may deny it. and that's what they like to do. So always, always, always respond to a request for evidence, no matter what it is asking for. Even if you have nothing to give them, then you say, I have nothing to give you, but you put in a response. And it's a good idea to use tracking when you mail it, so that we've had this issue too, where we've responded to a request for evidence, and then the case gets denied because we didn't respond to a request for evidence. And I've had to show them like the tracking to show, look, we mailed this out on time. You should have gotten it. We don't know why you didn't get it. And cases have been reopened in that way too. That is all today for notable approvals. Like I said, today was a short and sweet one, but a very important lesson nonetheless. Tomorrow's Friday, so I will see you on Monday for another notable approval. Thank you all for watching, and don't forget to like us, follow us on Facebook. And Twitter, Instagram, all that. If you have a request for evidence you need to respond to, or any other legal questions, our contact information is scrolling across the bottom of our screen. Please do not hesitate to contact us. Thank you all for watching, and have a great day.